Rule 1110. Prosecution of Offenses. The institution of a criminal action depends upon whether the offense requires a preliminary investigation. As a general rule, the offended party may not go directly to court to file a criminal action. Before a complaint is filed at court, there should have been a confrontation between the parties before the Lupon chairman. Where a preliminary investigation is required, a criminal action is instituted by filing the complaint with the proper officer for the purpose of conducting the requisite preliminary investigation. In such a case, a criminal action is instituted by filing the complaint or information directly with the municipal trial court of municipal circuit trial court, or by filing the complaint with the office of the prosecutor. Requisites of complaint or information. First, it shall be in writing. Second, in the name of the people of the Philippines. Third, it shall be against all persons who appear to be responsible for the offense committed. Distinguish complaint from information. As to be person who signed complaint, signed by the offended party, any peace officer or public officer. Information always signed by the public prosecutor of or special prosecutors. Rule 111. Prosecution of civil action. Reservation to file a separate civil action. When should be made? A. Before the prosecution start to present its evidence and under circumstances affording the offended party a reasonable opportunity to make such reservation. Prejudicial question is one which arises in a case the resolution of which a logical antecedent of the issue involved therein and the cognizance of which pertains to another tribunal. The law limits a prejudicial question for a previously instituted civil action not to a subsequent one. It may be raised during the preliminary investigation of the offense or in court before the prosecution rests in case. The suspicions of criminal case due to prejudicial question is only a procedural matter and is subject to a waiver by virtue of prior acts of the accused. There is no one prejudicial question where one case is administrative and the other is civil. Rule 112. Preliminary investigation. Preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. A preliminary investigation is required to be conducted before the filing of a complaint or information for an offense, where a penalty prescribed by law is at least 4 years, 2 months, and 1 day, without regard to the fine. Purposes of preliminary investigation. First, to ensure the innocence against hasty, malicious, and oppressive prosecution. Second, to protect the accused from public and open accusation of a crime. Third, to protect the innocent from the trouble, expense, and anxiety of the public trial. Fourth, to protect the state from useless and expensive prosecutions. Rule 113. Arrest. Arrest is the taking of a person into custody in order that he may bound to answer from the commission of an offense. Remedy of the accused: if a warrant of arrest is improperly issued, he must file a motion to quash the warrant of arrest. Arrest how made? An arrest is made by an actual restraint of a person to be arrested or by his submission to the custody of a person making the arrest, no violence or unnecessary force shall be used in making an arrest. The person arrested shall not be subject to a greater restraint than is necessary for his detention. Duty of arresting officer. It shall be the duty of the officer executing the warrant to arrest the accused and deliver him to the nearest police station or jail without unnecessary delay. Execution of warrant. The head of the office to whom the warrant of arrest was delivered for the execution shall cause the warrant to be executed within 10 days from its receipt. Within 10 days after the expiration of the period, the officer to whom it was assigned for execution shall make a report to the judge who issued the warrant. In case of his failure to execute the warrant, he shall state the reason thereof. Time of making an arrest. An arrest may be made on any day and at any time of the day or night. Rule 114. Bail. Bail is a security given for the release of a person in custody of the law. Bail may be given in the form of corporate surety, property bond, and cash deposit, or recognizance. Bail a matter of right. Exemption. All persons in custody shall be admitted to bail as a matter of right, with sufficient sorties or release on recognizance as prescribed by law or this rule. Before or after conviction by the Metropolitan Trial Court, Municipal Trial Court, Municipal Trial Court in the cities or Municipal Circuit Trial Court, and before conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment. Bail a matter of discretion upon conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment. After the conviction, when is bail a matter of discretion? After conviction, bail is a matter of discretion if the penalty imposed is not more than 6 years. If more than 6 years, bail will deny. Bail when discretionary upon conviction by Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment. Admission to bail is discretionary. The application for bail may be filed and acted upon by the trial court despite the filing of a notice of appeal providing it has not transmitted the original record to the appellant court. However, if the decision of the trial court conviction the accused changed the nature of the offense from non-bailable to bailable, the application of bail can only be filed when the resolved by the appellant court. Rule 115. Rights of the accused. Section 1. Rights of the accused at trial. In all criminal prosecution, the accused shall be entitled to the following rights: to be presumed innocent until the contrary is proven beyond reasonable doubt, to be informed of the nature and cause of the accusation, to be present and defend in person and by counsel at every stages of the proceedings, from arraignment to promulgation of the judgment, to testify as a witness in his own behalf but subject to cross-examination on matters covered by direct examination. His silence shall not in any matter prejudice him, to be exempt from being compelled to be a witness against himself, to confront and cross-examine the witnesses against him at the trial, to have compulsory process issued to secure the attendance of witnesses and production of other evidence in this behalf, to have speedy, impartial, and public trial, to appeal in all cases allowed and in the matter prescribed by law. Rule 116. Arraignment and plea. Arraignment is a proceeding in a criminal case whose object is to fix the identified of the accused, to inform him of the charge against him, and to give him arraignment and plea. How made? The accused must be arraigned before the court where the complaint or information was filed or assigned for trial. The arraignment shall be made in open court by the judge or clerk by furnishing the accused with a copy of the complaint or information, reading the same in the language or dialect known to him, and asking him whether he pleads guilty or not guilty. Plea bargaining is a process whereby the accused and the prosecutor in a criminal case work out a mutually satisfactory disposition of the case subject to court approval. Plea of guilty to a lesser offense, and arraignment the accused with the consent of the offended party and prosecutor may be filed by the trial. When the accused pleads guilty to a capital offense, the court shall conduct a searching inquiry into the voluntariness and full comprehension of the consequences of his plea. Rule 117. Motion to quash. Motion to quash is a special pleading filed by the defendant before entering his plea, which hypothetically admits the truth of the fact spilled out in the complaint or information at the same time that it sets up a matter which, if duly proved, would preclude further proceedings. At any time before entering his plea, the accused may move to quash the complaint or information. This motion must be filed before arraignment, otherwise it shall not be allowed anymore except a complaint or information does not charge an offense. Court lacks jurisdiction over the offense charge, extinction of the offense or penalty, or double jeopardy. A motion to quash is substantially the equivalent of a motion to dismiss in civil cases. Grounds for a motion to quash the complaint or information. First, the fact charged do not constitute an offense. Second, that the court trying the case has no jurisdiction over the offense charged. Third, that the court has no jurisdiction over the person of the accused. Fourth, that the officer who filed the information had no authority to do so. Fifth, that the information does not conform substantially to the prescribed form. 6. That more than one offense is charged exempt when a single punishment for various offenses is prescribed by law. 7. That the criminal action or liability has been extinguished. 8. Rule 118. Pre-trial. Pre-trial is a conference between the court and the counsel to consider the simplification of issue and necessity or desirability of amendments to the pleadings. Pre-trial agreements, all agreements of or admissions made or entered during the pre-trial conference shall be reduced in writing and signed by the accused and counsel, otherwise they cannot use against the accused. The agreements covering the matters referred to in Section 1 of the rule shall be approved by court. Pre-trial order. After the pre-trial conference, the court shall issue an order reciting the actions, taking the fact stipulated, and evidence marks. Such order shall bind the parties. Rule 119. Trial. Trial is the examination before a competent tribunal according to the laws of the land or facts put in issue in a case for the purpose of determining such issue. Time to prepare for a trial. After a plea of not guilty is entered, the accused shall have at least 15 days to prepare for trial. The trial shall commence within 30 days for receipt of the pre-trial order. Rule 121. New trial or reconsideration. New trial or reconsideration at any time before a judgment of conviction becomes final, the court may, on motion of the accused or at its own instance but with the consent of the accused, grant a new trial or recommendation. New trial is rehearing of a case already decided but before the judgment of the conviction therein rendered has been final, whereby errors of law or irregularities or expunged from the record or new evidence is introduced or both steps are taken. Grounds: errors of law or irregularities prejudicing the substantive right of the accused have been committed during the trial. New and materials. Motion for reconsideration may be filed in order to correct errors of law or fact in the judgment. It does not require any further proceedings. Grounds: errors of law. Second, errors of fact. Note, the principle underlining this rule is to afford the trial court the opportunity to correct its or mistakes and to avoid unnecessary appeals from being taken. The grant by the court or recommendation should require no further proceedings, such as taken or additional. Rule 126. Search and seizure. A search warrant is an order in writing issued in the people of the Philippines signed by the judge and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. Time of making search. The warrant must direct that is be served in the day time unless the affidavit asserts that the property is on a person or in the place ordered to be searched, in which case a direction may be inserted that it be served at any time of the day or night. Search of house, room, or premises to be made in presence of two witnesses. No search of house, room, or any other premises shall be made except in the presence of the lawful occupant thereof or any member of the family.